I would like to reserve maybe 3 minutes.
3
for
minutes,
rebuttal.
that'll be fine.
Thank you. Your Honor, I'm Greg Logue with the firm of Wolf McLean here in Knoxville. I represent Eva Havlicek and Save Pittman Center in this case. Briefly, what this case involves is the dismissal of a writ of certiorari taken from the Sevier County Planning Commission on a preliminary order at the Sevier County Regional Planning Commission. It resulted in a situation where the court, at a summary judgment that I filed on behalf of the plaintiff appellants, at that summary judgment hearing, the court brought up the subject matter jurisdiction as to whether this was a final order. We briefed that issue, and then after that, the court issued its opinion. Excuse me. And the reason why the case was filed was because of Judge McBrayer's case in the rural Franklin versus Williamson County. That case stands for the proposition that a preliminary ruling by a planning commission can be final under 27-9, 101, and 102, which is how you file a certiorari case. And what happened in that case was, in that case, there were objections made at the preliminary level, but they did not appeal in Williamson County. They waited until the final plat was approved, and as Judge McBrayer pointed out, those arguments should have been made at the time at the preliminary plat. And I will get into that in a little more detail in a minute. The facts of this case, very briefly, Eva Havlicek, my client, lives in Pittman Center, which is, as everyone knows, is a small community just outside of Gatlinburg. She built her house on the banks of Laurel Creek, on Laurel Creek Road, which is just off of State Road 416, not far from downtown Pittman Center, which I have a particular interest in that I was married in Pittman Center in 1983. And my wife is one of the original families in Pittman Center, so I have a fond affection for Pittman Center. But Running Rock Developments, the defendants in this case, they own a large tract directly adjacent to Ms. Havlicek's property in excess of 200 acres. They submitted a concept plan on June 30, 2023 to the Sevier County Regional Planning Commission. It came up for discussion or approval at the July 11, 23 meeting of the Sevier County Planning Commission. I appeared on behalf of my clients, and I noted 5 specific defects in the concept plan that did not comply with Article 3 of the Sevier County subdivision regs. Quite frankly, I don't think there's any dispute that those 5 things are not true. I think the issue here is the case was dismissed because Chancellor Ripley believed that was not a final order. But as I will point out, I believe it was. Now, I don't want to get into all 5 of the defects. I don't think that's relevant for today, but I'm just going to focus on 2 of them that I brought up at that Planning Commission meeting. Number 1 was the lot size. Under the Sevier County Planning Region Article 3, which you have to comply with for a concept plan, lot sizes must be 30,000 square feet unless there is public water or public sewer. This concept plan shows lots of 4,800 square feet, clearly, not in dispute. Secondly, they filed this concept plan as a planned unit development, and again, the planned unit development regulations, which again fall under Article 3, refer to you have to have public water or sewer. So both of those issues, along with the other issues, were brought up at that meeting. After making those arguments, the Sevier County Planning Commission unanimously approved the concept plan, set it on, and approved it. So once it was approved, again, knowing of Judge McBrayer's opinion in rural Franklin, I filed a case within 60 days and move forward. And again, brought up those 5 issues. Can I get some water? I'm sorry.
Yes. Yes. Do we have some water?
I'll continue. I don't want to.
Here. Yeah, you got it.
I'm sorry. I should have done that before I started.
Don't worry about it.
Okay. I think first it's important to understand the holding in rural Franklin. The holding in rural Franklin was not based on what stage of the process it was. The importance of rural Franklin is the significance of the stage that was made. And what was important in rural Franklin was the preliminary plat, which was stage 2 in Williamson County, basically approved the subdivision of the land. And so rural Franklin doesn't say it matters which stage it's at, it's what was the significance of that preliminary ruling.
Well, let's talk about significance ruling, and I'd like to say, for the Sevier rural Franklin case, I do take credit for all the mistakes. It's the court's opinion, but the mistakes are mine, so let me start with that disclaimer. One of the things that was significant in that case was that under Williamson County subdivision regulations, with preliminary plat approval, you could start making improvements on the property, which was significant in that case because once you started digging, the property changed. Could, under Sevier County's subdivision regulations, did a design plan allow for improvements to the property?
The concept plan, Your Honor? Okay. Yes, it does. And I was going to quote that language from your opinion in a few minutes, but I'll get to it right now. What the concept plan says, and I am quoting from transcript 1, page 88, which is the subdivision regulations. This is Article 2, B, paragraph 8. And what it says is, following concept plan approval, prior to construction beginning, the developer or his representative shall schedule a pre-construction meeting with the county planner, so on and so forth. Now, it goes on to say, the next step is the design plan. But I think what's important to remember about Sevier County, the design plan has no public involvement. So this decision to allow 4,800 square foot lots and a PUD took place, and then they start moving forward with construction. When you get to the design plan, which the public has no involvement in, says, the design plan shall consist of all detailed engineering, design, and construction drawings, calculations, and related documents necessary to construct the proposed subdivision in conformance with the approved concept plan and these regulations. Then it says in bold language, any construction work carried out by the developer prior to design plan approval or contrary to an approved plan shall be at the developer's own risk.
Is there a distinction in the subdivision regulations between a concept plan and a design plan?
Your Honor, in Sevier County, yes. Williamson County, no. Williamson County had, step 1 was the sketch plan. And interestingly, Sevier County has a sketch plan, but it's not even part of their three steps. They have a sketch plan as sort of like a pre-op or something, and it talks about a sketch plan. But in Williamson County, Your Honor, what they called a concept plan was really a sketch plan. Back of the napkin, let's talk about it. But when you get to Sevier County, the concept plan is where the real meat of it is.
Okay, so you're saying in Sevier County, concept plan under the subdivision regulation takes on more significance.
Exactly, Your Honor. And what I am saying is, to get to the point, is the concept plan in Sevier County is the same thing you ruled in Williamson County preliminary plat. In fact, the concept plan, if you look at, again, I'm on page 87 of transcript 1, a concept plan shall be required on all developments except minor subdivisions. There's no dispute this isn't a minor subdivision. As noted in Article 2.3b, the concept plan shall serve as the preliminary plat. And once that plat is approved, their construction begins, and it's undisputed. Mr. Mullins will not disagree that construction is taking place today. And the only way I stop that for my client is to file this case and ask the court to deny the concept plan, to overrule that decision at the Planning Commission.
So if that's the case, if you look at Article 2, which is the preceding page in the record, page 86, it describes 3 steps, but
Right.
then it says you don't even have to get approval for a concept plan. Why is that?
Your Honor, you do have to get approval for a concept plan.
Well, it says only 2 require appearances
Okay.
before the Regional Planning Commission
Right,
for
but it
review and
says-
approval.
But what it says, Your Honor, the initial step is, I'm reading from, again, Section 1 on page 86. The initial step is preparation and submission to the Planning Commission of a concept plan of the proposed subdivision for preliminary plat approval. If you go down to Section 3, just under that, in order to secure review and approval by the Regional Planning Commission of a proposed subdivision, the proposed subdivider shall, prior to making any street improvements, installations of utilities, submit to the Planning Commission a concept plan as provided in subsection B. You go to subsection B, Your Honor, and it says, the concept plan shall serve as a preliminary plat. And in section 2, it says, the concept plan shall meet the minimum standards of design set forth in Article 3. Article 3 is where I'm pointing out to the Planning Commission that you've got 5 things here that don't comply. And I will say, Chancellor Ripley, in his opinion, sorry, I should have had this up earlier. I think this is where I'm just about out of time.
That's fine.
If
You're
I
you're still answering.
Okay, I'm going to, okay.
Question.
I think where Chancellor Ripley missed the point, with all due respect to Chancellor Ripley, is in his decision, he focused too much on what stage of the process. And again, rural Franklin was not focused on the stage of the process. Rural Franklin was focused on the significance, the fact you can go out there and start doing construction. But what Judge Ripley says, and this is on page 3 of his opinion, he says, thus, while the preliminary plat submission is the second step in the process in Williamson County, it is the first step in Sevier County by explicit definition, and he uses the word merely, a concept plan functioning to give certain general information insofar as possible, such as approximate acreage and land to be subdivided. However, with all due respect to Chancellor Ripley, I think he misreads that section of the regulations. It says the concept plan shall meet minimum standards of design in Article 3. That's what I'm complaining about. And I think I guess I better stop here, but if you go on to the next levels, you go to design plan, what does it say? It comes back to it says, to construct the necessary plans in conformance with the approved concept plan. You go to final plat. The final plat shall conform substantially to the concept plan as approved. Your Honor, once that concept plan is approved, we're doing construction. And these issues, again, we're back to there's construction taking place. The only way I stop that is if the court would hear that motion for summary judgment and rule on it. That
Your time's expired, counsel.
Thank you.
We'll hear from the appellee.
Thank you. May it please the court, my name is Benjamin Mullins. I'm an attorney here at the law firm of France McConnell Seymour in Knoxville, Tennessee. I represent the appellee Running Rock Development, We filed a joint brief with the Sevier County Planning Commission. I'm arguing jointly on this. This case, Mr. Logue is correct. He filed a motion for summary judgment, arguing that the concept plan was defective. We did contest factually whether or not the issues that he raised, the defects that he raised, were or not defective. We don't believe that they were. We also, at the same time, filed our own motion to dismiss the case on subject matter jurisdiction based upon the verification issue that we have briefed. The court, in hearing both of those matters, decided that based upon its review of the Sevier County subdivision regulations, this matter was not ripe for adjudication, therefore did not have subject matter jurisdiction. And the language in the court's ruling, I wanted to draw attention to this panel, is given that only one step in the three-part step is complete in this case, coupled with the admission of the Planning Commission that its action is not final, the court concludes it lacks subject matter jurisdiction, such that this case must be dismissed. And that's because in Sevier County, the bulk of the approval process occurs after the concept plan.
Counsel, so make it simple for me. It's your position that until the third step, the final plat is approved, that there's no subject matter jurisdiction in court?
I think that's correct, Your Honor. At that point, the issues of whether or not we do have utility access, for example, or the final configuration of the lot size, that can change through, in Sevier County, through the design plan process and ultimately to the final plan. And that is the argument that the Sevier County raised as well. And so I think when you're looking at the subdivision regulation schemes, you need to look at they're different between each jurisdiction. Williamson County is different in this case than Sevier County is.
What does this allow as far as the way of construction that can be done before the final plat?
Well, I mean, there's certain construction. One of the things, when you do go through the design plan, you start to do some more engineering. You don't want to do the engineering until you know you at least have a back of the napkin sketch as to what you can or cannot do potentially moving forward. That gives you permission to invest more money in infrastructure in order to make sure that there is utility access, to do some geotechnical testing, to make sure that soils can perk if they're doing septic systems, to make sure you can put the road where they've drawn the road. You've got to be able to access the property. And so there have been some road improvements along my client's property, not in the right-of-way, that have occurred at this point. But that is just accessing the property.
Yeah, so I want to make sure that I'm clear, though. So there's let's start with Article 3 of the subdivision reg. So there's two different sections here, one dealing with concept plan and one dealing with design plan.
Yes.
And we're talking about a concept plan here that was approved or a design plan?
The concept was approved.
Yeah. And so the reg does say that the concept plan shall serve as the preliminary plat. I mean, to me, that is a significant language and distinction between what we had in the rural Franklin case. I mean, those were distinct steps in that case. And it sounds like in Sevier County that is not the case.
It is different, Your Honor, and I think that the nuance between the Sevier County subdivision regulations and the Save Rural Franklin case is what Chancellor Ripley focused on. Chancellor Ripley did directly address the Save Rural Franklin case in his opinion and did find it distinguishable. And one of the reasons was that the subdivision regulations state, and I think I misquoted the article, but it's with regard to the utility access, shall give information insofar as possible regarding general location of proposed utility layouts, connections to the existing proposed utility systems. That was one of the main defects that they were complaining of, is that we had inadequate utility access, but at that point in the concept, we didn't have enough information to do anything other than a general location.
Well,
that would need to be
I'm less
revised.
concerned about the claim deficiencies here. To me, that's beside the point of whether or not the court had subject matter jurisdiction to look at this. I'm concerned about whether or not improvements are currently being made on the property. Is that yes or no here?
There are road improvements, the driveway, again, the property was there's old logging trails generally following that, but they are widening that. But that would have to be done whether you were building 50 lots on 200 acres or one lot on 200
And
acres.
using the concept plan approval, could the developer here pull any permits or any permits? been-
Grading permits only at this point.
Grading permits, okay.
Going back to Save Rural Franklin, just quickly, Mr. Logue said that Save Rural Franklin stood for the fact that preliminary plat phase could be final. It's not necessarily final. And the language that you authored, Your Honor, on page star 18 of the opinion, it says significantly petitioners do not allege a final plat for Hillsborough Cove failed to conform substantially to the approved preliminary plat. But it goes on to say petitioners also made no claim related to final plat approval that had not already accrued with the approval of the preliminary plat. Here, that's different because the issues that are complained of, the exact location of the lots, the exact access for the utility, has not yet accrued, and won't know, whether that's the case or not until this additional engineering is done through the design phase to get to final plat. And I think that was the difference that Chancellor Ripley focused on as well. In Williams County, I don't think there was very little leeway for changes between the concept plan or the preliminary plat phase and the final plat, and here I think that is different. I want to talk about the verification argument. This was, the court did not, Chancellor Ripley did not address this argument one way or the other, but it is an issue of subject matter jurisdiction which can be raised at any time. It was something I raised at the trial court level in my motion to dismiss. And this court's and the trial court's jurisdiction to entertain this certiorari appeal is dependent upon plaintiff's compliance with both Tennessee Code Annotated 278106 and Article 7, Section 10 of the Tennessee Constitution. The statute requires that the petitioner's complaint be sworn to, typically before a notary, and the constitutional provisions require that it be verified by an oath or affirmation. Here, the court lacks subject matter jurisdiction because the petitioner was not properly verified. It was verified by the petitioner's attorney, not the petitioner herself. And I will admit this is probably a case of first impression before this court. I know there has been some trial courts that have ruled on this and have not made its way through this court already. But this court has not ruled on it. But there have been several cases involving inadequate verifications, and the court has consistently said that the petitioner must verify the contents of the petition and swear to the contents of the petition under oath and utilizing a notary public. And I've cited several cases in my brief that continues to repeat that language. But why is it important that it's the petitioner? Why couldn't the attorney do that on behalf of the petitioner? Well, it is a verified complaint. The verification has to show there's some level of aggrievement by the party filing the petition.
But the aggrievement here has to do with compliance with the subdivision regulations. And I mean, I would be hard pressed to say that a client would be able to go in and say, well, I know that I can match the plan up to the subdivision regulations and say it's not in compliance. I mean, you need a lawyer or someone that's in planning and codes to be able to say something like that,
well,
don't you?
the aggrievement has to also go to how it harms them particularly, not the public in general. And having a development that there may be some technical deficiencies with a concept plan, that doesn't necessarily harm anybody. The harm is, well, it's going to affect the access to my property. It's going to affect the right-of-way in that area. And these are issues that they have raised in their verified complaint. And that's where someone with particularized knowledge and a specific injury needs to be able to verify those issues.
Can we go back to the first issue again, though? It just occurred to me, I'm curious, one of the things that was significant about the first stage in the subdivision regs in the Williamson County case was that improvements had to be made in accordance with a preliminary plat. Is there similar language in the Sevier County, or do they say improvements made in accordance with the concept plan?
I think the improvements are decided at the design plan, and then they look at the improvements I agreed to in the design plan when they go to final plat and say, all right, is this, generally in line with what the concept plan provided, or is it significant enough we have to go back and reconcept it?
Okay, so that makes it sound like, though, the concept plan is pretty significant in the process because you're matching up the preliminary plat with what the concept plan gets approved.
But the meat of the issues are things that would require some engineering and some investment of really time and research that can't be done at the concept plan.
Can it be done for the design plan?
It is done in the design plan.
And the design plan, the public has no input on that?
No, at that point, they do have to file a final plat, and the final plat is where,
But-
the defects that he mentioned, the two, lot sizes and, the utility concerns.
I understand, but my question is, the preparation submission to the technical staff of the design plan detailing the construction plans and the proposed subdivision, public has no input at that second stage.
That's correct.
All right.
That is not a public process
They
at
have
that
input at
point.
the first stage for the concept plan, and they have opportunity to have input for the final plat.
That's right, Your Honor.
Okay.
Counsel, with reference to the subsection addressing design plan, I think it's Bates stamp 88, there's language in bold, any construction work carried out by the developer prior to the design plan approval or contrary to an approved plan shall be at the developer's own risk.
Yes, Your Honor.
Does that have any bearing upon or
I'm-
impact upon finality?
I'm glad you asked that question because that speaks to the very issue that if you do work under Sevier County's regulation, you are doing it at risk. You're not acquiring any greater rights because you've got a permit or because you've done some grading or some other work through the design plan phase to get to final plat. At risk means if the final plat is disapproved, you can't rely upon that.
Okay, well, maybe I'm not understanding the distinction between the concept plan and design plan under the Sevier County regulations. What are the distinction between those two?
Between the design plan
The
and
concept plan under B part of Article 3 and the design under C part.
And under C part of the design plan, I mean, it's the detailed engineering and construction drawings, calculations. You're going to make sure you can build the road where the concept plan shows the road to be built, that you can place the utilities in the area where the concept plan showed generally the utilities
And when
should
does that
go.
design, is that a staff approval or?
It is. It's a consultation between their engineers and the staff engineers at that point. On developments where a concept plan isn't required, that would be the first step, is you want to get
This
sure.
is not a minor subdivision, so you have to have that design.
This is not a minor subdivision or exempt subdivision, so you do have to have that concept, but you don't know that you can actually do that concept until you invest some time in the engineering phase of it. It's axiomatic that an attorney cannot verify an affidavit on behalf of a client. He can't sign interrogatories and verify them. He can't sign, there is cases on summary judgment. And I would submit to the court that under the verification for a common law writ of certiorari, that's no different, that the attorney can't do that because it is a verification. Why else would we require a verification if it doesn't require personal knowledge of the person making the verification? I know I'm running out of time very quickly here. I think I have a superpower whenever I get at the podium. Time goes faster than anybody else, it seems. The appellants did cite to the annotations, which had two cases under the note, affiants who are proper, that's DeWiggins v. Robinson and Foster v. Blunt. Neither of them are instructive to this case. None of them involve a common law writ of certiorari. They're all, one's an 1804 case, one's an 1808 case. That involves cases going up to the Tennessee Supreme Court at that time. One of them says the petition was sworn by only one defendant only. The order, however, was not reversed on that objection. So
All right, so
that was a defendant that verified
I
it.
understand, but let me see if I can summarize your position on this. You're saying under the law, the complaint needs to be sworn to, verified by a layperson who can't possibly.
They need to verify the factual allegations of it, Your Honor. I mean, otherwise, how else does anybody have personal knowledge? Personal knowledge is always a requirement for a verification. That's what the Tennessee
And you're saying a
Constitution
layperson's going
provides.
to be able to come up and look at the plans and look at what's there?
They're going to be able to say...
Let me finish. Come up and look at everything that's there for the concept plan, and then say, oh, look, here's where it all, here's where it doesn't satisfy these things.
I think they would consult with an attorney, but I think their verification would be the facts as to how that affects them, and that goes back to the issue of aggrievement.
Okay.
I'm out of time, Your Honor. I'd be happy to answer any additional questions.
Thank you. Rebuttal.
Do I have any time left? Okay. First of all, with the issue on the verification, that Foster v. Blunt case, it's cited under the notes to the decisions under the certiorari section. So someone thought it was important to put it there, and it basically, for all practical purposes, an agent can sign the petition for the plaintiff or the petitioner. And I think in principal agent, the principal has knowledge or has imputed knowledge, I guess, of what the agent does. I mean, that's the whole point. But here, I had all kinds of personal knowledge. I was the one that made the arguments. And so I think that's a non-issue. But going back to something Judge McBrayer asked, again, I'm going to read from this from the rural Franklin position opinion. It says, hey, this is on page 14 of the Lexis version of this. A final plat may only be submitted after the proposed subdivision has been approved. And then it says, perhaps more importantly, prior to the approval of the final plat, the developer may commence improvements in accordance with the preliminary plat that could significantly, if not permanently, alter the land. Your Honor, Phase 1 in Sevier County, I believe, is extremely close, if not almost identical, to Phase 2 in Williamson County. And I think that's what's important here is you look at...
Well, the Planning Commission is saying here, well, no, not really, because all you're doing is widening a road and drilling some holes.
I understand, Your Honor, but the land is being significantly changed today. And I think it's interesting, Sevier County's not even here today. We're here for oral argument. The county's not here. But again, one last thing. And again, I think the significance...
Would it be allowed to do something like, in addition to roads, there's a hill on the property and they simply level it off?
I think they can, Your Honor. I think what is going on up there right now is modifications to a right-of-way that begins exactly where my client's property stops up through this property. And a bunch of issues, we also raised issues about the size of the right-of-way, the size of the pavement, all of these things. And I think if you look at these regulations, once the concept plan is approved, I think that is analogous to the subdivision being approved. That's when the big decision is made. When does this start, when does this go forward? And again, again, I go back to Article 2, Section A, Paragraph 3, that says, in order to secure a review and approval of a proposed subdivision, the proposed subdivision shall, so on and so forth, submit this concept plan. And then it says, on approval of the concept plan, he may proceed with the preparation of the design plan, final plan, and other documents. That's the key point. This issue about 4,800 square foot lots, the utilities, there's no public water system, but they approved a concept plan knowing there was no public water system or sewer system. This is a rural area of Sevier County. I'm out of time.
Well,
I appreciate the
Yeah,
court.
before you go,
Okay.
I'm going to give you a little extra time to answer a question here,
Thank you,
though.
Your Honor.
What in the subdivision regulations, I appreciate a developer could say, you know what, I've got money I'm paying interest on, I want to get started on this, I don't care if I have sign off, that happens. But what in the subdivision regulations lets them do anything more than what you've described in Article 2A3? I mean, that A3 describes basically paperwork. You know, we're doing design, we're drawing up a final plat. What in the subdivision regulations do I look to and says, well, you can do more than that?
Okay. Your Honor, what it says in the concept plan under Section 8, this is on page 88, it says, following concept plan approval and prior to construction beginning, the developer or his representative shall schedule a pre-construction meeting with the county planner. This meeting shall be held to discuss the work to be undertaken and the design and construction process related to stormwater, wastewater, water, electric, roadway, drainage. That's going forward, because you get to the design plan and it says, to construct the proposed subdivision in conformance with the approved concept plan and these regulations. So this issue about allowing substandard lots and all these things, the way I read this, they can go forward. And this is all being done without public comment. This is being done between county planners and the developer. We have no idea what's going up there right now. That's why I believe this was properly filed and should have been, quite frankly, granted summary judgment on, but for the fact that Chancellor Ripley dismissed it for lack of subject matter. I appreciate everyone's time and attention this morning. Thank you.
We appreciate council's arguments and their briefs on this. If you would, please recess court till 1:30 this afternoon.
All right.